anybody hear?
I can hear.
Yes, this is Jay Cabu for the petitioner. We can hear as well.
Thank you. We're hearing our case 1 CASA 20-0109, Hernandez Reyes versus Collins, the state real party in interest. Each side will have 20 minutes to present their argument. Petitioner, you may save time for rebuttal, but you have to keep track of your own time. We are recording the argument, so when you
I think we just lost Judge Katani. He was frozen there for a minute. There he comes.
there.
There you go. You're muted though. You're muted.
I should make sure I'm not muted also.
Now, you can hear me now?
Yeah.
Okay. And so when you begin the argument, please identify yourself and your client so that we can keep everybody straight. We've read the briefs, we've conferenced the case, and the three of us have talked about it. So we're familiar with it. So when you begin your argument, just launch right into what you want us to know. Counsel, you may begin.
Thank you, Your Honor. May it please the court. Good morning. My name is Jay Cabu from Perkins Coie on behalf of Ernesto Reyes. And with the court's permission, I'm going to attempt to reserve for myself 3 minutes for rebuttal. As the legal advisor to the grand jury considering Mr. Reyes's case, the prosecutor had an obligation to explain not only the law governing the grand jury's consideration of the case, but also the relevant facts, including all the exculpatory evidence about which the state knew. As to the law, this is a case of justification, and the state was obligated to advise the grand jury on ARS 13205, which is critical to defining
Counsel, how do you a grand jury proceeding has a probable cause standard. A jury trial has proof beyond a reasonable doubt. If we instruct on justification defenses, how does a grand jury proceeding now end up being a trial?
Your Honor, thank you. What I think the critical difference is that without 13205, the grand jury doesn't know what the crime is that it's considering. The crime here, because of the way 13205 works, the crime here is probable cause, or what the grand jury is being asked to find here, rather, is probable cause to believe that the shooting was unjustified. Because as the court said in Carson, the Supreme Court said in Carson, when it passed Section 13205 in 2006, the legislature made a transformative change into how these cases are not only tried, but also how they're considered by the grand jury. The question here is what conduct is criminal? And in the context of a case where there's any evidence of justification, and here no party disputes that there is at least some evidence sufficient to trigger justification, in a case like this, the grand jury's inquiry is probable cause to believe the use of force was unjustified. And without 205, the grand jury has no guidance on that. And
aren't they instructed on, they were instructed here on 405, they were instructed on justification in general, just not the ultimate trial burden, weren't they?
Your Honor, I agree that they were instructed on 405. Where I would take issue with Your Honor's characterization respectfully is that it's just the trial burden that comes up in 205. And I think we can look to the Supreme Court's ruling in Cespedes to learn that. Cespedes, again, was a justification case like this one, although there it was in the context of the parental discipline privilege. But in Cespedes, all 7 justices noted that it was correct to read 205 to the grand jury, because without it, the grand jury does not understand the inquiry. The inquiry is whether the use of force was unjustified. And that
Cespedes that broadly. I read it as the court did not properly instruct, that they confused the jurors. And given the instructions that were there, the jurors were confused, which I think is different than saying you necessarily have to instruct on 205. Am I wrong on that?
Your Honor, I would respectfully disagree, not that you haven't read the case correctly, but rather about the question before the court and what that means for our collective inquiry today. Before the court in Cespedes, as Your Honor just mentioned, was a case where 13205 was mentioned and it was described. And in the majority opinion, the court at paragraph 11 explained that, quote, the prosecutor correctly advised the jurors that they were going to be making decisions about justification and certainly can decide whether the acts were justified. And again, that was a case where 13205 was read. So there was no question, should they or shouldn't they read 13205? They read it. The majority ultimately held that the less than clear reading of 205 and the explanation of the law surrounding it was still sufficient to meet the due process requirement and thus denied the motion to remand. But Justice Lopez in dissent really put the issue quite starkly, where he said very clearly in paragraph 28, where evidence triggers a justification instruction, a lawful probable cause determination requires a grand jury to find that an action was not justified.
Well, and I understood the discussion in Cespedes, though, was that the prosecutor said, well, you're going to have to find justification. Well, no, you're not going to find justification. That's going to be for the trial. And there was confusion as to whether the grand jurors had to consider justification at all, not necessarily what the ultimate trial burden was going to be on justification. And that doesn't seem to have been at issue here.
Well, Your Honor, I guess in response to that, I would note that this court's relatively recent opinion in Dominguez, which is the subject of a supplemental authority that we filed and an opinion by Judge Johnson, addressed this particular issue of whether or not there's a basis to draw a distinction between the legal instructions given to the grand jury and the legal instructions given to the petty jury considering that exact same case. And there in Dominguez,
go to the burden of proof, did it? Wasn't that just whether the Thompson instruction on premeditation, whether the actual instruction on premeditation was accurate without the Thompson clarification? That seems very different than let's go through exactly how the burden of proof works at trial.
Well, Your Honor, I think our good-natured dispute here is about whether 205 is about the burden of proof at trial or whether it's about defining the scope of the offense. And I would respectfully urge that 13205 defines the scope of the offense because it is there and only there that the grand jury learns that the question before it is whether the use of force was unjustified, rather than was there a use of force, and then as an affirmative defense at trial, is there an excuse for it? And the Carson case and others are clear that 13205 is not an affirmative defense. It is a burden that the defendant must never bear. The burden is always at every stage of the proceeding because it defines the offense itself. The burden is always on the state to prove that the use of force is unjustified.
But in finding probable cause, we're going to instruct the jurors that the defendant has to first prove this by a preponderance, then the state's going to have to prove the converse by beyond a reasonable doubt. That seems very confusing in the context of, is there probable cause for this offense?
Your Honor, I agree that the hypothetical you just set out would be confusing, and we are not contending that is the prosecutor's job here.
But isn't that what 205 says? Isn't it kind of confusing when you juxtapose it with is there probable cause for the offense?
I think, Your Honor, that at least to me, the way that I've thought about this case is that in it, where there's any evidence of justification, and again, that's the trigger. It's not a preponderance, even in a case of affirmative defense, which this is not, right? This is not a case of we have to show by some quantum. No one disputes that there are sufficient facts here to trigger justification. The question is, on those facts, where there is any evidence of justification, like there certainly is here, what is the offense for which the grand jury here is being asked to find probable cause? And we would respectfully suggest that drawing from Cespedes, drawing from Dominguez, that the grand jury question, the question to be put to the grand jurors and on which they must vote is, do you find probable cause to believe that the defendant use of force was unjustified.
But cancel under 205 that, and the state would have to have the opportunity to rebut that, and you would have in a grand jury proceeding, you would end up having these shifting burdens going back and forth that are seem to me more properly resolved in a petty jury, not a grand jury. And I'm not sure how that would work.
Your Honor, I believe that how it would work is that in a case where there is sufficient evidence to trigger justification, and again, this is not a close question, that Carson and the cases about justification make pretty clear that it's any evidence, the very low threshold. The prosecutor's job as the legal advisor to the grand jury in such a case is to say there is evidence sufficient to warrant this instruction, and therefore your question, grand jurors, is, do you find probable cause to believe that the use of force was unjustified?
Counsel, that still sounds different than, and could I just take a step back? Your client did not specifically request 205, did he? Or what was there a request for 205?
There was a request that all applicable statutes be read. There was a citation to Cespedes, and there was a list.
But what I'm asking, they didn't come in and say you've left out 205. Is that right?
No, we didn't know that they had left out 205, and frankly, on the facts of this case and against the background of Cespedes, it didn't. We did not think they would leave out 205. That was a surprise to us.
Okay, so you just found out after, and so you objected. But is there ahead of time? I mean, the way you've couched it seems a little bit clearer and I mean less confusing. Didn't you have an opportunity to say we would like a modified something that points to what's covered in 205 that would not be so confusing in the context of a probable cause determination? You didn't submit a different type of instruction that would have covered that without somehow to try to make it less confusing, at least from the way I'm reading it.
Your Honor, you're certainly correct that we did not propose a grand jury instruction in the way that at a trial you would propose jury instructions. But the obligation for the prosecutor to instruct them correctly exists irrespective of any, flagging or prodding from us. And it certainly exists in this case. If 13205 is required to be read, then it was required to be read here, no matter what we said. I think going back, I would certainly agree with Your Honor that we could have said that, and I think the court should probably anticipate that in the future I probably would say that. But we didn't have to say that in order to trigger the grand jury's, the prosecutor's due process obligation as legal advisor to the grand jury, which is otherwise ex parte, to make that instruction clear and known. I'm happy to continue on the issue of 205, but I don't want to fail to at least discuss for a moment the fact that 13205, the failure to read 13205, is not the only reason for which the indictment must be remanded in this case. On the facts, too, in addition to the legal instructions, on the facts as well, the state failed in its constitutional duties to make the presentation that they are required to make. And specifically, the state failed to do here what the court in Bashir versus Pineda said very clearly must be done in a case where, as here, the defendant has given a detailed Trevis letter setting forth important factual background and making clear that the defendant would testify. Here, as in Bashir, the prosecutor made a perfunctory statement to the grand jury that the defendant wanted to testify. That's exactly what happened here. The state had a Trevis letter that detailed Mr. Reyes's request, detailing the history of documented threats against him, the fact that the victim initiated the confrontation on the night in question, and the fact that Mr. Reyes reported it as soon as it was safe to do so. And here, all the state said was, quote, and this is at Appendix 44, the subject, Ernesto, has provided information that he shot at John that night because he felt in fear of his own life as well as his daughter's life. That was a very short summary and a slanted summary Of what?
Was there also, though, additional information about having reported threats previously? It seems to me there was other information that certainly was along those same lines.
There was, Your Honor, but there's two separate constitutional requirements in play here, and it's important that we not confuse them. One is the right of the defendant to have the grand jury evaluate his request to testify with the information about which he would testify, and that's in Bashir, right? The grand jury would view his request to testify differently if they understood what he was going to say, and that's the court in Bashir explained that at paragraph 20. The issue Your Honor mentions just now is a separate duty to present exculpatory evidence known to it. Now, we believe they failed on that as well, for example, because they never said anything about prior death threats against Mr. Reyes's brother and about the prior occasion where Mr. Reyes's ex-wife threatened him with a loaded pistol. But those are separate constitutional failings of the state in this matter. So the duty of the state to provide a detailed summary of his testimony is clear, and that is independent of the state's duty to present any exculpatory evidence. And
so
as
you would agree there's some discretion on the part of to not present cumulative information. That if there's enough to trigger it. I mean, this one's a little more difficult. It seems like there's some room for discretion to decide how much, and if there's something, and if the trial court thought that was enough to put them on notice, that this seems like a more difficult challenge for you.
I agree, Your Honor, that of the two fact-based challenges, the failure to present exculpatory evidence in and of itself is our most difficult challenge. I agree with you there. I don't agree that has any bearing on their failure to accurately summarize in detail sufficient to advise the grand jury about what he's really going to say. I don't believe that they met that standard at all. The state argues in its briefing before this court that any summary quote whatsoever of the testimony is appropriate, and that is flatly contradicted by Bashir, and for good reason. If the grand jury is to discharge its independent function as a check on the prosecutor and as a guardian of the defendant's rights, the grand jury has to be told a straight story. They have to know what this person is going to say. Now, we're not saying that the grand jury was required to hear Mr. Reyes. We are not saying that. What we are saying is that as they made an independent judgment about whether to hear from him, they had to be told, because of what happened in Bashir and the court's reasoning in Bashir, they had to be told what he would say in fair detail. We went to a lot of trouble in multiple single-space pages to lay out that detail, and they did not summarize that detail. All they said was, he wants to testify. That is not enough.
But didn't they make clear that he thought it was justified and he wants to testify? Do you have to go into a lot more detail? He says he was justified. He was afraid for his life, and he wants to testify. Why wouldn't that put the grand jurors on notice that he might have some information that we'd like to hear?
That's not sufficient to meet the constitutional requirement set forth in Bashir that where a defendant requests to appear before a grand jury, and I'm quoting now at paragraph 22, provides information with some degree of detail as to the subject and outline of the proposed evidence, the prosecutor has a duty to convey that information to the grand jury. They didn't convey that information to the grand jury. They conveyed the fact that he wanted to testify and no more. They did not convey the substance of the testimony, and they are required to do so, and they were certainly required to do so here. With that, Your Honors, if the court has no questions for me right now, I would respectfully reserve the balance of my time for rebuttal, if that's okay with Your Honors.
Thank you, counsel.
Thank you, Your Honor.
Counsel, you may be.
Thank you, Your Honors. Good afternoon. My name is Amanda Parker, appearing for Real Party and Interest, the state of Arizona. This court should find that respondent judge did not abuse her discretion in denying the motion to remand. The defendant in this case was not denied a substantial procedural right under Rule 12.9. The grand jury presentation was fair and impartial. I want to start by addressing some of the points that defendant made. Even citing to the defense in Cespedes, paragraph 28, Justice Lopez references 12-205, not for the proposition that the grand jury must be told about the state's burden at trial. Then regarding the defendant's supplemental authority that he filed yesterday, Dominguez, as I think Judge Catani pointed out earlier, Dominguez dealt with whether the grand jury must be given the same elements of premeditation as the petit jury. Dominguez made no mention whatsoever of informing the grand jury of the state's burden at trial. And as the state argued in its response to the petition for special action, Cespedes highlights why 205 is confusing and would be confusing to be presented to the grand jury. Regarding the statutes that were presented in this case, the grand jury was given copies of the statutes. They were asked if they wanted the statutes reread. They were asked if they wanted the statutes clarified, including the justification statutes. And we know from the language in Crimmins that instruction on all of the relevant statutes satisfies due process.
What puts the grand jurors on notice that there is a different burden with regard to justification? Shouldn't they know something about that? It seems to me 205 is a little bit confusing, but why not let them know that it's actually the state's burden to disprove a justification and an assertion that the act was justified?
There's certainly nothing wrong with the state explaining that, but it wouldn't be required under due process or 13-205.
Why not due process? It seems like a pretty big change to say that it's the state's burden to disprove justification. Wouldn't jurors just automatically assume the contrary? Everything else is always that's something the defendant is trying to prove. It doesn't seem intuitive that the state is going to have to disprove justification. It seems like something the defendant would have to prove if I were just thinking it through logically.
Well, when the prosecutor in this case directed the grand jury to the statutes for the actual offenses, there was no discussion at that point about the state's burden of having to prove those elements of the crime. Similarly, the justification statutes that were referenced immediately following the crime statutes, there was no discussion about the burden, but we presume the jury understands the term justification. It's a commonly understood term, and especially in this case, given the facts of this case, due process did not require an additional instruction. And it certainly didn't require the state to inform the grand jury about the state's burden at trial.
Would you object if the defense submitted a different instruction that just suggested that if there is evidence of that the act was justified, it becomes the state's burden to disprove it, rather than it's not the defendant's burden to prove justification, it's the state's burden to disprove it, without going into reasonable by a preponderance, and then the state has to disprove it beyond a reasonable doubt? Would something like that make sense? Would you?
Potentially. I don't want to say that the state would object to that. I think that potentially opens the door to explaining, like, when is that burden triggered, and then you have to have the jury make a preliminary finding that justification has been triggered. The state certainly wouldn't object to something or a request for that first part of 205 to be read that just explains what a justification defense is. But the defendant's argument in this case has never been, we are asking for some limited explanation of justification. His argument has consistently and persistently been that the entirety of 13-205 needs to be read, and the state has consistently objected because it improperly gets into the state's burden at trial. But I guess to answer your Honor's question, the state wouldn't object if a defendant wanted a definition of justification potentially read, as long as it doesn't get into burden shifting. But again, in this case, due process.
But there is a different burden though when justification is raised, and shouldn't the grand jurors be aware that it's different? You don't disagree that there's at least a viable justification defense in this case?
I agree that the grand jury should have been pointed to the justification statutes, and they were pointed to the justification statutes, yes.
And they don't need to know anything about the kind of the sea change that came about with 205, that it did kind of change the burden and how these cases were tried.
I think in this case, because there was no explanation about the general burden with the statute, that were initially read regarding the underlying offense. I'm not saying that the state would object to that in future cases, but certainly the state would respectfully request that this court not hold the state to read the entirety of 13205, which talks about the burden. And that was the issue that has been presented in this special action. Strictly was whether the state has to read 13205. So whether a separate instruction would be requested or appropriate in a different case, I'm not sure what the state's position necessarily would be, but the state has objected in this case because the defendant has requested that that trial burden be given to the grand jury. Regarding the defendant's argument about the evidence, the respondent judge correctly found she did not abuse her discretion in finding that the grand jury presentation was fair and impartial. As I think the court pointed out in petitioner's opening, there was other information presented during the presentation to the grand jury, including that the victim had threatened the defendant in 2018, which was almost a year prior to the crimes in this case. The grand jury was told that the victim and defendant did not get along. The grand jury was told, in fact, that the victim was yelling that he was going to kill the defendant immediately before the defendant then shot the victim. And the other thing I wanted to point out that Cespedes itself talks about this being an objective standard and what is reasonable objectively in that situation. So the presentation to the grand jury was very fair and impartial considering the standard for justification and that the justification statutes require an immediately necessary use of force or deadly force. I also wanted to point out—
Opposing counsel drew a distinction between just presenting some exculpatory evidence and highlighting what the defendant wanted to personally present to the grand jury. Is there a reason the prosecutor should not have or presented more information as to what the defendant wanted to present through testimony?
A couple of responses to that. Bashir talks about the prosecutor's obligation to outline the proposed testimony from the defendant when a sufficiently detailed letter has been given. In this case, the general statement about the alleged conversation between the victim and the defendant's brother, there was no date or time frame given for that. And the state was also aware that the alleged incident between Mariana and the defendant occurred potentially 3 years prior to the date of the crimes in this case. But I do think that the defendant is right that the standard in terms of whether the grand jury has what it needs to make an informed decision about whether it wants to hear from the defendant is a separate question from the state's obligation to explain exculpatory evidence. And in this case, the grand jury was not deprived of its choice about whether it wanted to hear from the defendant because the outline of the testimony coupled with what was already presented to the grand jury adequately gave the grand jury what it needed to know to be able to assess whether it wanted to hear from the defendant in this case. Does the court have any other questions?
I don't.
No, thank you.
Thank you, Your Honors.
Counsel, you have rebuttal.
Thank you, Your Honors. I'd just like to make a couple of points, and I would like to start with this. Justified conduct is not a crime at all. And as the Supreme Court made clear in Carson, in 2006, the legislature in Arizona, in response to a lot of back and forth about a lot of cases that were part of the sort of stand your ground movement, the legislature made clear that a justified use of force in self-defense of your person, of another, and of an occupied vehicle, all of which come into play here, is not a crime. The grand jury's job is to decide whether a crime was committed. And if the grand jury, whose job it is to decide whether there's been a crime, does not have to be told that the question is, was it unjustified? They aren't doing their job. They can't. It's only in 13205 that the grand jury would learn that this is not an affirmative defense. And I know my colleague just mentioned that it would be somewhat burdensome to read all of 13205. That we respectfully disagree. The grand jury statute reading day is laborious, it's computer generated, and it's reams of statutes that have nothing to do with every single case they consider. In this case, the prosecutor could have simply started by reading 205. That wouldn't be burdensome at all. It's 5 lines of text. And it's only there that the grand jury learns that this is not an affirmative defense. That's critical. It's critical to understanding whether a crime occurred. On the issue of the letter, I think
you would agree that there's still, even with a solid probable cause, is a much lower standard than proof beyond a reasonable doubt. So even assuming a really compelling justification defense, it seems hard to overcome just a probable cause showing. That it does seem to be more of how is this ultimately going to be decided at trial, with this is the burden and this is how it gets resolved. But if you start with the premise that probable cause is not nearly as high a standard as proof beyond a reasonable doubt, it seems hard to say, and I have a hard time getting past how confusing 205 would be in the context of probable cause. Sorry to ramble.
That's okay, Your Honor. By my clock, I see my time has expired. I'd be happy to answer Your Honor's question, and I would like to do so.
Please.
Okay.
Please.
Thank you. I actually can't see the court's clock anymore, so I apologize for any inconvenience. I would say this, Your Honor. I agree that probable cause is a much lower standard, and there's certainly no dispute among the many lawyers and judges today who have thought about this that it's low. But as we've all sort of experienced over the last 40 minutes, it's tough to sort through. And the grand jurors, without an instruction on 205, has no chance of getting it right, because we haven't told them how to do that. And while I agree that the burden, that there might be more sort of edge cases because of a higher burden at trial beyond a reasonable doubt. In other words, there are likely to be more cases between preponderance and beyond a reasonable doubt than there are perhaps between probable cause and zero. Right? I don't want to sort of engage in the taboo of assigning numbers and percentages to those, but certainly there will be more so-called edge cases at trial. But that doesn't mean that the threshold is meaningless. It doesn't mean that in a case, as Your Honor said, where there is compelling evidence of justification, and we certainly believe that's the case here, that it doesn't matter, and that we can sort of apply a broad brush and say, well, it doesn't matter if they understand that it's not the defense's burden to prove anything. I think it's critical to understanding the crime, and that ultimately is the grand jury's task. It's the grand jury's task as an independent investigative body, as a check on the power of the executive branch, to determine whether a crime has occurred. And ever since the law was changed in 2006, as the court pointed out in Carson, the crime here is unjustified use of force. And until the grand jury understands that, they can't do its job. They can't do their job.
Thank you, Counselor. We appreciate your arguments today. We'll take this matter under advisement, and we'll issue a decision in due course. We stand adjourned.
Thank you, Your Honor.
Thank you.
Thank you.